Hello friends, this is Sanjay. In this video series, we will cover the interpretation of statute subject from the LLB syllabus of Chaudhary Charan Singh University or CCSU, Meerut. The syllabus is common for both the 3-year and 5-year LLB programs. The complete playlist is available on the Lawment YouTube channel. While I have covered all the topics that are specifically mentioned in the syllabus, I have also included some additional concepts and topics which are required for a better understanding of the subject and also helpful if you are preparing for any post-LLB exams like the CLAT PG, UGC NET or Judicial Services. The timestamps for the specific topics as per the syllabus are in the video description below. This is part 7 and we will cover the interpretation of statutes with reference to their subject matter and purpose. Before we look at the interpretation with reference to the subject matter and purpose of statutes, we need to understand some basic concepts. We have already discussed how statutes can be classified on the basis of their subject matter and purpose. A point to remember here is that statutes will normally come under multiple categories. For example, a statute may be a codifying statute. It can also be a taxation statute. And because it has some penal provisions, it can be considered to be a penal statute. And because it operates prospectively, it is a prospective statute. And since it does not have any specific expiry date or a sunset clause, it is a perpetual statute. So rather than classifying entire statute, probably it makes more sense to classify specific sections or provisions of statutes. In any case, we have also discussed the primary and secondary rules of interpretation. Under the secondary rules of interpretation, there are these two principles of strict and beneficial construction of statutes. In both strict and beneficial constructions, the advantage of any ambiguity should go to the person on whom these laws are being applied. When we talk about the interpretation with reference to the subject matter and purpose of statutes, we are essentially talking about how these two principles, that is, strict or beneficial construction, should be applied to various types of statute. More specifically, how they apply to penal statutes, taxation statutes, and welfare statutes. What are taxing statutes? These are nothing but statutes dealing with the levy of any kind of tax. They can also be called revenue statutes since they generate revenue for the government. These taxing statutes may deal with direct taxes like income tax or wealth tax or indirect taxes like the GST. Without looking at the bigger picture that taxes are ultimately used for the welfare of the people, if we look at the immediate effect of a tax, it creates a burden on the person who is paying the tax. If taxes are not paid, then the taxing statutes may create a liability, a penalty, or lead to a punishment on the person who is being taxed. So, if a statute has the potential to create any kind of burden, liability, penalty, or punishment on the people, it should be interpreted strictly. Now remember, the strictness is on the statute and not on the person, which means that if a tax statute is not fully clear about whether a particular transaction is taxable or not, the benefit of that doubt should go to the person who is being taxed. Strict interpretation means that the scope of the statute is limited to whatever is specifically mentioned in that statute. No additional taxes can be inferred, implied, or extended beyond what is specifically written in that law. For example, when e-books started becoming popular, then the tax laws still had not caught up with the concept. So, if you were selling a book in both physical and digital versions, only the physical sales could be taxed, and the digital copies were exempt because the tax laws did not specifically mention anything about digital books. So, the strict interpretation of tax statutes meant that the benefit of the gap in the law went to the publisher, till the law was amended to include digital goods also into the tax net. In summary, if a taxing statute needs interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted strictly, and it is interpreted in favor of the person. The other basic principles to be followed include harmonious construction so that the interpretation does not lead to contradictions within the statute itself or with other statutes. Also, new tax laws should be applied prospectively on transactions occurring after the enactment of the statute and not on past transactions that occurred before the law became effective. and the beneficial provisions of a statute that give any exemptions, deductions, or rebates must be interpreted to benefit the taxpayer, and any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Penal statutes or criminal statutes define that specific activities are illegal or criminal and prescribe some penalties, liabilities, or punishments. The interpretation of penal statutes is similar to that of taxing statutes, because even here the rule of strict interpretation is applied. The meaning of strict interpretation means that if an action is not specifically defined as being illegal or criminal under the statute, then the person who is being accused cannot be penalized. If there is any ambiguity or doubt, then the benefit of such a doubt goes to the person who is being accused. For example, smoking cigarettes or BDs in public places is illegal and people can be punished for doing so. But when e-cigarettes became popular, the statutes at that time were not clear. Is smoking e-cigarettes in public places a crime or not? For the purposes of the statutes, are e-cigarettes considered to be in the same class as regular cigarettes or not? So these were the questions where there was not much of a clarity. Since there was a doubt and the strict interpretation was applied, it meant that people could not be punished for using e-cigarettes in public places, unless and until the statutes were amended or updated. If a penal or a criminal statute needs interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted strictly, and strictly in favor of the person. While interpreting penal statutes, the concept of mens rea or guilty mind also becomes very important. That is, unless the statute explicitly says so, an act will not be a crime unless the person intentionally commits it. If an act was unintentionally committed or accidentally committed, then it will not automatically become a crime. The other principles that are applied are beneficial construction and harmonious construction. Another important aspect about penal statutes is that a person cannot be punished for an act that was not a crime when it was committed. That is, penal statutes cannot be applied retrospectively, and this is also specifically prohibited by the Constitution. For example, if a statute banning e-cigarettes was enacted from the 1st of January, then a person cannot be punished for having used e-cigarettes on the previous day, that is, the 31st of December. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Social welfare statutes are enacted to promote social justice and provide benefits to the people. For example, the Mahatma Gandhi National Rural Employment Guarantee Act, the Right to Education Act, the National Food Security Act, or the Rights of Persons with Disabilities Act. Since the objective of such statutes is to extend benefits or to ensure the welfare of the people, they should be interpreted beneficially and liberally to ensure that all the intended beneficiaries are covered. For example, if there are some benefits that are to be extended to people with disabilities, and there is a question about some disabilities that are not specifically listed in the statute, then the court can use common sense and reasonable construction to see if the disabilities in question should be covered under the statute or not. If there is a reasonable doubt, it should ideally be interpreted in favor of the beneficiaries, because it is okay if a few unintended persons benefit from the statute. No intended beneficiary should be deprived. As is the case with all statutes, if there is a need for interpretation, the primary rules are applied first, and then for social welfare statutes, the court should use beneficial interpretation. Another point to remember here is that social welfare statutes should be interpreted dynamically to ensure that the statutes stay relevant with the changes in the society. For example, there are some laws and rules that offered some benefits to people working in offices. And after the COVID pandemic, working from home also has become normal, which means that the statutes that covered work from office should be suitably interpreted to cover employees who are working from home also. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Your university syllabus for this subject may include a topic Interpretation of Substantive and Procedural Statutes, or it may say Interpretation of Substantive and Adjunctival Statutes, or it may say Interpretation of Substantive and Adjective Statutes. If you pause the video here and read the dictionary meanings of the words adjunct and adjective, you will see that in the context of laws or statutes, they are referring to the same thing, that is, procedural statutes. The terms substantive and adjective seem to have been invented by Bentham in 1843 and subsequently popularized by Holland when he used these terms in his book. But these days the preferred term is procedural, since adjective and adjunctive do not clearly indicate the purpose of these statutes. A simple example of a substantive law and an associated procedural law are the Bharatiya Nyaya Sanhita and the Bharatiya Nagarik Suraksha Sanhita. The Bharatiya Nyaya Sanhita defines various crimes and specifies the punishments. So this is a substantive law. And the Bharatiya Nagarik Suraksha Sanhita provides the procedures for giving effect to the substantive law. So this is a procedural law. As I have previously mentioned, procedural or adjunctive or adjective statutes are all referring to the same thing, that is, procedural laws. Modern jurists prefer to use the term procedural law because it provides more clarity as to what is the purpose of the law. It is easier to understand the interpretation of substantive and procedural statutes if we study them together. First of all, there are substantive statutes which define legal rights, duties, obligations and liabilities. For example, the Bharatiya Nyaya Sanhita, the Indian Contracts Act and the Transfer of Property Act are all some examples of substantive statutes. Then come the procedural laws, and as the name itself indicates, they provide the procedures for implementing the substantive laws. For example, the Bharatiya Nagarik Suraksha Sanhita provides the procedures for implementing the Bharatiya Nyaya Sanhita. And if a substantive law needs some interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted either strictly or beneficially depending on the nature of the statute. Is it a penal statute, is it a welfare statute, or any other type? The rule of casus omissus is also applied here, which means that if something has been omitted or is missing from a statute, then the court should not try to fill that gap through its own interpretation. The court should interpret the law as is. Procedural law is always subservient or secondary to the substantive law, which means that the procedural law cannot supersede or override the substantive law. For example, the Bharatiya Nagarik Suraksha Sanhita cannot take away anything that the Bharatiya Nyaya Sanhita has mandated, or it cannot add something that the Bharatiya Nyaya Sanhita has prohibited. Procedural statutes are generally interpreted liberally because their purpose is to enable the implementation of the substantive law and not become a roadblock. The Supreme Court has also noted that a substantive right accrued to the litigant should not be defeated by citing a procedural defect that is capable of being cured, which means that minor procedural irregularities can be overlooked if they don't affect the substantive rights or the merits of the case. And in general, procedural laws apply prospectively because a law should not create a new procedure and expect that procedure to have been followed in the past from before the enactment of the statute. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. What is the meaning of prospective and retrospective operation of statutes? First of all, consider the effects of a statute. They can be legal, social, economic, political, etc. These effects are essentially the creation of some rights, benefits, liabilities, offences, obligations, etc. If suppose a statute comes into force from the 1st of January of 2024, it will have effect on the subject matter of the statute from that date onwards. So, if any actions, events or transactions that are covered by the statute occur on or after the 1st of January of 2024, the statute will have an effect on them. This is the prospective operation of a statute and this is the normal operation of a statute. However, what about any actions, events or transactions that occurred before the statute came into force? Under normal circumstances, the statute will not affect these. However, in some situations, a statute may work retrospectively and have a backdated effect on them. A point to remember here is that just because a law is enacted, it doesn't mean it has become effective. The date from which the law becomes effective may be specifically mentioned in the law itself, or may be mentioned in the Gazette when the law is published, or the government may issue a separate notification on a future date to specify the date from which the law becomes effective. So, prospective operation is the general rule, and statutes normally affect the events, actions and transactions that occur after the statute or the law has become effective. This ensures predictability and protects existing rights, which means that if people are expected to follow a law, then that law should be applicable at that time. Retrospective operation, where a law affects the events, actions or transactions that happened before the law or the statute came into effect, is less common, and it requires a clear intention from the legislature regarding the retrospective effect. Article 21 of the Constitution prohibits ex post facto application of criminal laws. That is, a person cannot be punished for something that was not a crime at that time. For example, if a speed limit on a road is fixed at 60 km per hour from the 1st of January, then people should not be punished for driving faster than 60 km per hour on the previous day. In a particular ruling, the Supreme Court held that not only criminal laws, even civil laws that impose penalties, forfeitures or other burdens that are of a criminal nature are prohibited by Article 21 because their effect is similar to punishments under a criminal law. Typically, retrospective statutes tend to be amending statutes. They clarify an ambiguity in an existing law, so they can be applied retrospectively. But remember, the amendment should be clarifying only and should not amount to significantly changing the law. Sometimes retrospective statutes may be curative in nature, that is, they correct or cure any past legal mistake, legal flaws, or historical injustice. In both these cases, if the statute is creating a right or creating a benefit to the affected people, then this retrospective effect will be welcomed. The Central Goods and Services Amendment Act of 2018 had a retrospective effect. Since this retrospective effect was beneficial to the taxpayers, it was valid. The Finance Act of 2012 amended Section 9 of the Income Tax Act with retrospective effect. This was done after the Supreme Court's decision in the Vodafone case. Now, this amendment of Section 9 led to quite a bit of a debate about the fairness or rather the unfairness of such retroactive tax laws. Another interesting example is the 2016 amendment of the Benami Properties Act. This was a situation where the government claimed that the amendments enabled a civil action whereby the Benami property would be forfeited or taken over by the government. But the Supreme Court held that this amendment was not procedural in nature. This was in fact a substantive law. Therefore, it cannot be applied retrospectively. Also, the forfeiture of the Benami property was a punitive action, leading to a penalty or a punishment, similar to a criminal law. Therefore, it cannot be applied retrospectively. With that, we have come to the end of this part about the interpretation of different types of statutes. If you have any questions or feedback, post a comment below. Thank you in advance for your like, share and subscription. We will meet again in the next video. Take care and Jai Hind.